get started. So hi, and thank you for joining us for today's webinar on employment law crossover cases. It's designed to help your clients and your firm as well. Before we get to introductions, I'd like to make a few housekeeping announcements. This webinar is pending MCLE credit. In order to qualify for the credit, you'll need to stay logged in for the entire session. Hopefully, we'll have time to answer many of your questions. If you do have questions, please click on the Q&A bubble on the bottom of the screen and type them there. My name is John Blake, and I'm the Director of Sales here at Gemini Legal. We're always striving to bring new and valuable content to the applicant workers' compensation community in California. You'll be able to find a recording of this and our prior webinars on our Gemini Legal YouTube channel. You'll also find attorney interviews and other helpful information there. I'm thrilled to be joined today on my panel by two great employment law attorneys that will each share some unique perspectives that I think we can all benefit from. I'll let each of them introduce themselves, starting with James.
Okay, hi everybody. Thanks for joining us today. I'm Jim DeSimone. I have my own firm, V. James DeSimone Law. I'm also of counsel to Boehm Law Group, so we really practice throughout the state of California. I'm an employment lawyer, but I'm also a civil rights lawyer. So in addition to employment law, I do a lot of police misconduct cases, school liability cases, always looking to collaborate with people and work with good people. And I've been doing this for quite a while, over 30 years, and look forward to a good panel today with my good friend, Gian Houck.
Okay, and
Thanks,
Gian,
Jim.
go ahead.
Hi, everyone. My name is Gian Houck. I am one of the co-founders and a partner at the Houck firm. I started my law firm earlier this year with my husband, and I practice primarily plaintiff-side employment law, and I'm excited to be here today.
Wonderful. Well, with that, we're going to go ahead and get right into this. We have a lot of information to cover, and an hour goes by really quick. So I'm going to start right from the beginning. So what types of questions should the applicant workers' comp attorneys be asking at intake to find out if there's an employment law issue?
Well, okay, I'll start out with that one. I mean, one question is, have you made any complaints about anything that the employer has done? Have you been retaliated against in any way? Have you been subjected to anything that you feel is discriminatory? Is there any adverse employment action, such as a demotion, termination, change in job duties, failure to promote? Is there a hostile work environment? Often when people are injured on the job and are requesting accommodations or requesting time off, the company responds in ways that are not lawful. And those are some of the types of questions you can ask to see if this is something where you should partner up with an employment law firm to help out your client.
Yeah, I think also, I mean, all that I echo, and also if there's anything else that's kind of illegal happening in the workplace that maybe as a result of some sort of health and safety violation, that's why they got hurt, or maybe they were complaining that we don't have the right safety equipment to do this job, and then they got hurt because of that. Those can give rise to a claim as well.
Great. And what are the most common types of cases that come up in conjunction with the workers' comp case?
The typical case that I get from workers' comp attorneys are disability discrimination cases or disability harassment. Like Jim was saying that, a lot of times employers, even though they are required to reasonably accommodate disabilities, they don't like to, right? It can be a burden on the employer or whatnot. And so that can lead to a hostile work environment. Maybe it starts off with some sort of bullying or pressure to work outside your work restrictions. It may even result in some sort of pretextual adverse employment action, which means they make up some other reason and demote you, or make up some other reason, write you up, but really they're trying to get you fired because they just don't like to accommodate you anymore. So those type of failure to accommodate cases are also very typical. And also the employer in California has an affirmative duty to engage in a good faith interactive process. So that means that once they're on notice that you have some sort of disability, they need to work with you as the employee to see if there's any way that they can accommodate that disability so you can continue to work. And so we see a lot of employers failing in that respect as well. They do the bare minimum and they think they've done enough, and the law requires more than that. So those are the typical type of claims that I see from the work comp, arising from work comp injuries.
Jim, anything to add?
Well, our clients have really been subjected to bad harassment and sometimes even physical in the workplace. You know, those individuals can have psych injuries, and sometimes there's physical manifestations of those psychological injuries. And I know primarily I've heard, well, psych injuries are hard to advance on for workers' compensation, but where the harassment is so prevalent and so over the top, and I've had a few of those this year, it really can make for a good psychological injury case as well. So in a way, the reverse, the employment case comes first, being harassed in the workplace, and you have to show that it's harassment based on some protected class or sexual in some way. Any type of sexual harassment is obviously unlawful. And then we're the ones referring our clients to workers' compensation attorneys because they clearly have a workers' compensation claim as well because they've been injured in the workplace.
So before I want to get into a couple of the more interesting cases, but before I do that, just following up on what you just said, when in the process should you get an employment attorney involved if you're a work comp attorney? I know you both have opinions on this, right? So
sure.
Go ahead, Gian.
I mean, early and often, right? I mean, I've seen cases that are not quite ripe for maybe Gemini to sign it up, but there are things that are happening in the workplace that could use our, input, right? So, reach out to an employment lawyer, like if your client's employer isn't respecting their work restrictions, right? And so, like I had a case recently where the employer gave them a modified work assignment, put in the letter that we identified a modified work assignment for you where you are able to sit for most of the time that you're performing this job duty, which is one of the work restrictions. And they had a no prolonged standing work restriction. And so I understand in the work comp parlance, that means 75% sitting and 15% or 25% standing. So they identified this thing, they put in this letter on, corporate letterhead, we found this job for you. Well, in truth, once my client got there, he couldn't do the job sitting, right? So they put it on this piece of paper that this was, they found this job for him, but he couldn't do it sitting. So he told his work comp attorney this, and he told the employer this, but by the time I got the case, nothing was in writing. So all I have is my client's oral testimony that he told the employer this. Obviously, the employer now is denying that he ever said that and denying that he couldn't do this job sitting down. So had a phone call been made earlier, I would have said, document, make sure that this is in writing, that you're saying I can't do this job. And what that does is then triggers the employer's duty again to engage in the interactive process and find a reasonable accommodation that he can do.
Yeah, I absolutely agree. I mean, as a trial lawyer, I can't tell you what a difference it makes to have those types of emails or letters from the client and to be able, as the client's explaining what they requested, to have that up on a screen in front of the jury to show, yes, it's what they requested and here it is in writing. So, we're mostly contingency fee lawyers. I mean, so we strike a balance, but so many times in my career, I've stepped forward, especially if it's, a friend who is doing the workers' comp case and, hey, I need a little input. Well, let's work together to have, I always like it to come from the client first. I don't want to write those letters, have it in the client's own words. But before that client sends it, make sure that we review it and really make sure it says what it needs to be said. And I always emphasize to my clients, make sure you're polite, make sure you're direct, make sure you tell them how much you value your job and want to keep your job. These are all important things because, you don't want to send emails in the heat of the moment. That can come back to bite you. The old saying, dance like no one is watching, but write your emails like they will be read aloud in court one day. And if you take these cases to trial, they will be.
I like
Yeah,
it.
and Jim, I think you raised a good point too, is that sometimes there may be competing motivations in work comp and in employment where like I've had a client tell the QME examiner that he doesn't want to go back to work until he's fully cleared, right? Or he doesn't want to go back to work until the work comp case is over. And that's something that I think as a work comp attorney, you need to advise your client that, if you won't go back to work with restrictions and there's nothing that the employer can do to accommodate you, then, that can, they can lawfully fire you, right? They can lawfully say that there's nothing we can do to accommodate you and sorry, see you later. So, making sure that you're having those conversations with your client about, not, for you're making sure that they can still do the essential functions of the job, with or without an accommodation is important. And you may want to consult with an employment lawyer about that.
Right, that interactive process goes both ways. The employer has the obligation, the employee does too. And the more the employee can identify how they can do their job with reasonable accommodations, the better our case becomes if the employer doesn't provide that reasonable accommodation. And to the extent that there's some tension between the goals of the workers' comp case, talk to the employment attorney and figure out what's in the best interest of the employee. Obviously, we're all lawyers in business, but our central goal should be to do what's in the best interest of the client. And oftentimes, the employment case can get more of a bang in terms of compensation for the client. That being said, there's advantages to workers' comp, and I want to make sure that I'm not leaving anything on the table or hurting the workers' comp case either by anything I do.
Yeah, absolutely.
And there's a question about reasonable accommodation. I just want to hit it quick. It just came in.
Sure.
Question says, we've had cases where employers require the employee to find the job online on their own, and that is their own responsibility to do so. How can that be argued?
Okay, so that's just not the law. I wish I had the case off the tip of my tongue, but I'll find it and maybe I'll send it to John. You can circulate it. But there is a clear case that says that's not enough. You can't just point the employee to search on the job postings and find something. They have an affirmative duty to go and look for something that they can do.
And actually, that case that you found, Gian, from the CELA conference that we both enjoyed this past weekend down in San Diego, Cower versus Foster Poultry Farms, which just came out last week, analyzes that whole issue and really puts it on the employer to affirmatively look in terms of what jobs could that person do. I mean, you had a person in that case who really, she fell and broke her wrist at work because they didn't provide her slip-free shoes. She kept asking for different shoes. She breaks her wrist, and then they told her, "Oh, you can be a pallet driver," and she's like, "But you need two hands. You have to do this work." And the guy's response was, "I drive my car with one hand sometimes. You can do it." And there were all these other jobs that the company had, and they didn't give her preferential treatment. I thought, I was going to speak a little later, but it's really some great language. Cower versus Foster Poultry Farms just came out. I don't have an official site. That's KAUR, but it basically says that, look, if someone has a disability, and that's where it's analyzed here, not in workers' comp, you have to give that person preference for open jobs. So the company was doing restructuring, like, oh, well, we had other people. No, it's okay. Someone has a disability, that person gets preference for open positions. That's the law. That employers don't know that, but that's where having someone like us come in to advocate for that can make a difference for that employee, which, as most of my clients say, when I say, well, you should see a psychologist, they say, I don't need a psychologist, I need a job. So, everybody wants to work.
Yeah.
Most people.
So, on that note, let's go ahead and get into a few cases. So I know there are some interesting cases out there that these folks should probably be aware of. Gian, did you want to start?
Sure. So this is not a Court of Appeals opinion, so I don't have anything to point to, but I had recently heard about a trial win of one of our colleagues, and they succeeded in a jury trial against the work comp carrier in an aiding and abetting theory, aiding and abetting the violation of FEHA, which is our anti-discrimination statute, the Fair Employment and Housing Act. And I hadn't really heard of this, hadn't heard of this before. So basically, they sued the employer and the work comp carrier for firing this person, refusing to reasonably accommodate this employee. They had settled with the employer beforehand because the employer said, hey, if the work comp carrier had given me the right information, we would never have fired him. We would have found a way to accommodate him. And so then the work comp carrier, though, refused to settle. They went to trial, and the employee won. And what came out of this litigation was that very clear evidence that there is such a huge incentive for these work comp carriers to close out their cases and improve their closing ratios. It saves them money, it gets them bonuses, all of these different things, right? So they want to improve their or increase their CNRs, or the compromise and releases, so that there's no future medicals or no future liability. So they want to close out these cases, right? And so in this case, they were able to find lots of communications. All of those phone calls are recorded, and emails and things that were basically pressuring the employer to fire him. Is there any way that you can, get rid of this guy? Because they know that a fired employee is more likely to settle their work comp case, right? Because they're desperate for money.
Yeah. And
also, a lot of times CNRs require a voluntary resignation. So they're not really willing to do that, right? And also because, they, I think those are the primary reasons, but, I just found that fascinating. So, to the extent that, it's definitely something I'm pursuing in all of my kind of crossover cases right now.
that's great. And Jim, you had one that you wanted to discuss too, right? Seas Candy?
The Seas Candy case, but and some of the work that we're doing with COVID related cases. But I do want to comment on what Gian just had to say, because a lot of times employees, if they see that the company's treating them unfairly, they quit. And that never helps us in the employment case. I mean, the constructive discharge the standard is very difficult. Employees are better off requesting leave. I mean, most of the time you have some sort of, just request a leave. If there's an investigation going on, whatever's happening, just have, as long as it's legitimate. But I think in most of these cases, they are. Much better for the employee to request a leave. That puts them protected. If they quit, it's just not a great dynamic for trial, where someone just leaves and throws up their hands, because the employer then isn't really given a chance necessarily to rectify the situation. So, yeah, I did want to speak about the Seas Candy case, which is a recent case, because it's outside of us representing just the employee, because in Seas Candy, you had a situation where the allegations were that the employer, Mr. Eck in that case, basically got COVID at work, and he died. And his wife got COVID as a result and became very sick and had long haul COVID symptoms. And in Seas Candy, it found that there was not the derivative injury doctrine didn't apply. For instance, if someone gets injured at work and then there's a loss of consortium claim, my understanding is that, that person can't necessarily recover for that person's injury because of workers' comp exclusivity. But in this instance, it's the wife herself who has been injured as a result of getting COVID and was able to press forward on this case under Seas Candy. Now, my understanding is that the Ninth Circuit has asked the California Supreme Court in a different case to opine on this. So we'll have to keep our eyes open as to whether or not that will end up being law after, in the near future. Of note in Seas Candy is that the wife could not maintain a wrongful death case. And I recently had it out with a judge in Riverside, and I think I have one more bite at the apple of this after he was initially skeptical, where I do have a wrongful death case against the county of Riverside based on our client's allegations that her husband requested to be able to work from home, caught COVID at work. But the difference is this. I'm using this case, Bugatti versus Department of Rehabilitation. And Bugatti is a case that everyone should be aware of because, in any workers' compensation context, because what it holds is that if an employee requests a reasonable accommodation and they're not provided that, and as a result of the failure of the company or refusal of the company not to provide that accommodation, the person gets injured or the prior injury is exacerbated, then that can take it out from under workers' comp exclusivity. I mean, you still have the workers' comp case, but we also then can sue under the Fair Employment and Housing Act for the physical injury. And Bugatti was a woman who had leg issues with her leg, some leg injury. She requested parking closer, and she ended up, they refused to give it to her. Her injury was exacerbated. She was allowed to sue under FEHA. Well, here's my theory. If someone requests the reasonable accommodation to work at home because of disability, because they have their vulnerabilities, and the company didn't provide them with the ability to work from home, and they get COVID at work, and as a result of their vulnerabilities ended up dying from COVID, then Bugatti should apply because it's a FEHA case. Then they requested reasonable accommodations, they didn't get it, they got sick and died. And why should the company get a windfall, so to speak, because the person actually died? In other words, if they requested a reasonable accommodation and they got injured, under the reasoning of Bugatti, that person can have a FEHA claim. Well, the fact that they got sick and died, companies shouldn't get a pass because of the death. And I have this in a few different cases. There's been no appellate decision on it yet, but that's I think it makes rational sense. I know COVID is kind of a hot button topic, but so many companies sacrificed and did the right things in following the rules. But I have cases in which companies just blatantly disregarded any safety concerns and people paid for it with their lives. And in that case, I feel like the companies, it's the right thing to hold them accountable for that.
Yeah, no, I like the argument. It sounds like with the reasonable accommodation that it should hold up, but sorry, I'm not your judge. So hopefully it works out.
I haven't had any COVID cases go very far. So I don't have personal experience on those, but yeah, I think it's really hard to make the argument that it's some sort of undue burden on the employer to allow from work from home when we all did it, in all industries, basically for, years,
yeah.
And so I do have a couple COVID related cases, but I hadn't seen them through like MSJ or anything yet.
Got it. All right.
I'm happy to share my briefing.
Yeah, and I did include both of those cases in with the reference materials. So if somebody needs to see them, I know, Gian, you just sent that other case to me. I didn't. I'll send that out after the webinar so everybody has the link to that one. So another question that I had, what do you wish the workers' comp attorneys did that they're not doing now? Or when is there a disconnect between the workers' comp attorney and the employment law attorney? When do you find that happens?
I think I touched on a couple of things that already. I think one is that there may be some motivation, let's say, to overstress the injury and the restrictions, but that may be that may kind of butt heads with the employment case, because then, if it's so restrictive that the client can't return to work and perform the essential functions of the job, that there may not be a reasonable accommodation. Now, a leave of absence is a reasonable accommodation. So it's not that they have to go back to work right away. So if the employer can accommodate the leave of absence, and that's a accommodation that they need to give. But once that leave of absence starts to kind of look indefinite, is when then we get into some issues, because there's no requirement that they give an indefinite leave, right? But there's also no black and white rule about how long is too long. It's all a case-by-case inquiry that they need to be making. And the burden is, again, on the employer to show that it's an undue burden to give 5 months as opposed to 4 months, or 13 months as opposed to 9 months, or whatever it is. So, but with that said, if it starts looking like the client's never going to be able to go back, or the employee is never going to be able to go back and work, then it makes our job harder to say that the employer failed to reasonably accommodate that employee. I think another thing too, like just by personal experience, I've had a case where really great gender case, totally not related to the work comp. And then I later found that there was I know that there's like some form settlement agreements, but sometimes applicant attorneys can enter into a long form settlement agreement. And in this case, there was a long form settlement agreement that was very broad, released all claims. I've never seen it since. So it's only happened once in my career, but it was a very broad release that released all claims, including FIHA. And so that was a case that we couldn't pursue. So maybe, that was early in my career. Maybe everyone got the memo after that, because I hadn't seen it since, but that's definitely something you need to consider before, letting your client sign that agreement. One other thing, and maybe I'm taking up too much time, Jim, sorry, but another thing that I see as well is that after termination, sometimes there's advice given to the client by the work comp attorney to go on disability. And that might not be the best thing for him or her, because if she is able to work with or without accommodation, it may be better for her to go on unemployment and get unemployment benefits. Because if you're getting at disability benefits, you're making a representation to our state government that you're unable to work, right? And so that may affect your ability to recover economic damages in our FIHA employment cases. So that's another time where we may be in conflict or butt heads a little bit.
Yeah, that's right. And and similarly, I've had a situation where my client has come to me and said, well, my workers' comp lawyer said I shouldn't be looking for work. And of course, we have a jury instruction in our cases where, under mitigation of damages, if someone isn't searching for work, then that could cut off our ability to recover economic damages. It's an affirmative defense, but if someone affirmatively says, I'm not looking for work, and so there is that, there's some sort of line, and really I think it's on a case-by-case basis. I mean, how, if a person truly is so disabled that they're not able to do any work, well, that's something that, it is what it is, and maybe they need to go on disability. But if it's in one of those situations where they might not be able to do the job that they had, and the company let them go because they weren't able to reasonably accommodate them, there are still jobs out there that person may be able to get. I always ask my clients, not only to look for a job, but make sure you're documenting it, because now with online searches and everything, take screenshots, do whatever you can I used to ask people to come in and I said, I want to see a stack this thick. Now it's all, electronic, put it all on a thumb drive or put it in a Dropbox folder, whatever works. But you really, and then if I have a pile like that at trial, the defense doesn't know what to do with it. It's just like, how can you say he's not or she is not looking for a job? So you really want to have, just as you want your client to document any, requests for accommodation and so on, and any other issues in the workplace, you want them to document that job search. So, the question, what would we want workers' compensation attorneys to do is pick up the phone or write us an email. Let's talk, let's talk about the client. Let's work together to make sure that we both have an understanding of what our goals are you as a workers' comp attorney, us as employment attorneys, and try to figure out together what's in the employee's best interest, because it's hard for the employee if they're getting one set of advice from me and another set of advice from the workers' comp. I don't want to, pull rank and say, well, your employment case is worth a lot more money, because I don't want to do anything that hurts the workers' compensation case either. So, let's work together. In a similar vein is let us know when the deposition is. I mean, so sometimes workers' comp cases, the deposition comes up really quick. For us, I mean, our depositions, somebody, in state court, depositions are limited to 7 hours. What is the one exception? Employment law. I don't know who made that decision. Should have been there. I know some of my colleagues that I respect, they think, oh yeah, well, we need more time to take the defendant's deposition and so on. I'm like, well, you could work that out in an individual case, but please, I mean, we in the past, and we've had employment law cases that have gone on 3, 4, 5 days. I know that doesn't happen in workers' compensation. So maybe a little bit less care is given to the workers' comp deposition, not, but I mean, I haven't, clients who say, yeah, well, I met with the workers' comp attorney, like, half an hour before the deposition, and we talked and then we prepared. That could end up biting us in the employment case. So I know we're all busy lawyers, but if a deposition is coming up and there's an employment law case or the potential of an employment law case, let the employment law attorney know. I've had my associates sit in on those depositions. I take the time to work with the workers' comp attorney to prepare them for those depositions. I've done that where it's me, the workers' comp attorney, and my client preparing them for the workers' compensation deposition. Lean on us a bit because we take, and I'm sure everybody has different approaches, but we definitely preparing our client for the deposition is like one of the most important parts of our job as plaintiff employment lawyers, because, while I often tell my clients, you're not going to win your case in deposition, there are things you can do that you can lose your case, and we try to avoid those things.
Yeah, great advice. And same with the trial. If there's a trial coming up, certainly let the employment lawyer know, because it hasn't come up in my practice yet, but there was one where there was a trial moving forward, and we actually sent folks there to ask the questions instead of the work comp attorney, and of the main harasser, who was also going to testify. So the trial ended up being continued and it never happened, but make sure you loop us in on that.
Good deal. So a couple of questions that came out that I think I can hit on. So one was, we file a lot of psych claims under workers' comp. At what point does harassment rise to the level of civil lawsuit causes of action?
Well, I think you can always assume that there may be something there for harassment. I mean, the recent case, this Cower case, is pretty awesome because it holds that even an adverse finding for workers' compensation, that there was no 132A claim, which under the facts seemed like a really bad decision for the workers' compensation judge. I was like kind of floored when you read the facts. It's like, well, come on. But hey, we all have been there, bad judges, bad juries, it happens, but it did not preclude a FEHA harassment case. So you really want to look at a couple different things. I mean, one is the harassment based on any protected class, and that could include, of course, a person requesting time to deal with their injury, time to go to the doctor, that sort of thing. But there could be other things at play. I also have, under the labor code, employers need to do everything reasonably possible to make the workplace safe. And now that doesn't mean that if they don't, there's an automatic cause of action. But if they don't, and then I combine this with Civil Code 43 sometimes and Civil Code 52.1. Civil Code 52.1. If somebody uses, it's our state civil rights law, but you don't have to be under color of state law. So if someone uses threats, intimidation, or coercion to violate someone's rights, we have the right to a safe workplace. Something like, well, if you don't do this work that's dangerous, you're going to be fired. Well, that seems like a threat. That seems coercive, right? You can have a cause of action under Civil Code 52.1. I had a case where defendants kept saying, we don't understand your theory, we don't understand your case, right up to the time that the jury, ended up awarding $5 million in punitive damages and $2 million in compensatory under a Civil Code 52.1 claim. And boy, they offered $425,000 to settle. I said, you got to come to 500, and that 75 grand difference, we stood on it. We took that case to trial. So that is something that you want to look at in terms of if the harassment or the threats, intimidation, or coercion that is threatening someone's job. Now, I will caution you that under 52.1J, it says that if it's only verbal, that it has to involve some threat of violence. But my argument is, well, it's not only verbal. You're threatening the person with their livelihood. You have taken away their job, or there's conduct involved. You had an adverse employment action. You wrote the person up. You did something else besides make that verbal threat. I think they wanted to take it out from, two people arguing that you could have a civil rights claim out of that. But oftentimes in the employment context, it goes beyond just being a verbal threat. There's something that the employer is threatening the employee, and it's something to take a look at it as well.
Okay. So Gian, there's another question here that I think you can tackle. How do you maximize case value when a lot of workers' comp claims are low wage earners making for low economic damages?
Okay, so I'm assuming that this means in the context of the employment case, in the FEHA case.
I think
So one thing I have to say about, because I don't know about the work comp world, but in the FEHA case, one thing I would stress to everyone on this call who does this work is that our emphasis on economic damages needs to be it just needs to be decoupled from the emotional distress. I think these cases are emotional distress cases most of the time, unless you have a high wage earner, and then there's obviously wages to that are part of the damages calculation. But a lot of our clients are low wage workers. That doesn't mean their emotional distress is worth any less, right? And I think for too many years, and even today, I have defense attorneys that are arguing, oh well, this is like three years salary for your client. That's so much, whatever. Mediators are saying that too. But when we look at jury verdicts, they're not tying, they're not tying the emotional distress damages to whatever wages they lost. If anything, our low wage workers can't survive a month, 2 months, without earning wages. And so that impacts their emotional distress. A lot of times we go to trial in these cases, we waive economic damage because there's such a low, we don't want it to be tied to that low number. And so if you look at some of these verdicts that are coming out recently post-COVID, they are low wage workers, and their emotional distress damages, are significant. And so, I don't think about maximizing economic damages anymore. And I'll tell you, when I first started, that's how I was trained, that we wouldn't take cases unless they were out of work for a year and there was some sort of economic damages that were already accrued. And I don't look at that anymore at all because, these cases are mostly emotional distress.
Yeah, I couldn't agree more. There's no, unlike punitive damages, there's no, law that says that there has to be some ratio between economic damages and non-economic damages, such that your non-economic damages are limited. I mean, I think the whole thing, this 4-to-1 ratio on punitive damages, does a disservice to people. But that's a story for a different day. This whole constitutional limitation on punitive damages based on that ratio just seems nonsensical to me. But exactly, I mean, the prevailing view in our case is if you have any sort of low medical, medical compensation, lost wages compensation, just waive those. You don't want that number to anchor a verdict down, and just go after the non-economic damages. And it really is, this continuum. The worse the conduct of the employer, the worse that someone's harm, the more outrageous the conduct, and in terms of how someone is impacted emotionally and mentally, the more likely that we can make a contingency fee case out of it. So, I wouldn't be so concerned about that. And yes, those low income workers are often the most vulnerable, and we can really use that as a way to hopefully get a fair settlement or compensation through trial.
Yeah. Another question, when should 132A be filed and not filed?
I mean, I don't know the answer to that in the work comp world, but that Cower case that Jim was talking about, that I think John's gonna circulate, makes it very clear that there's no, we're gonna talk about this later, I think, but there's no preclusive effect if you do file a 132A in workers' comp, and then you get an adverse ruling on that. We could still bring the FIHA cases in civil court, but I don't know, Jim, if you have any other insight about that.
I think it's, that's more of a workers' compensation specific question, but I think it should be filed any time you believe that your client is being harassed or retaliated in some way, and because of their injury, or they're making a workers' comp claim. And what Cower emphasized, I mean, if you look at the specific language of 132A, it seems pretty limited. But the case law, as I understand it, from having done a little research, and partially for this panel, honestly, is that it has a more expansive view. So it's been liberally construed to apply in other circumstances anywhere where an employee is penalized in some way as a result of an industrial injury, which means at work. Now, of course, keep in mind that for us, it doesn't matter where the injury happens. Is if the client gets injured outside of work, but the employer is retaliating against them, then that's a case where we come in. So where you have the, where maybe somebody's been injured a little at work or had pre-existing or something like that, bring in an employment lawyer. So I would say, file them whenever you think it's possible. I do know that there have been times in our settlement agreements that, and I always try to clear this with the workers' comp lawyer, where of course, we have no power to waive your workers' compensation claim. That being said, I'll make sure it's in the settlement agreement, right? Because I don't want anyone to claim otherwise. I mean, Workers' Compensation Appeals Board. But I have seen, and where we have done it, where the employee agrees not to pursue their 132A claim as a result of our settlement agreement, right? Because we're getting compensated for harassment. But okay, so you filed it, then you can't pursue it. I get how that might, mean a little bit less for the workers' comp, but it could be in the best interest of the employee to do that, because we don't have any cap on what we can recover for that harassment.
So question for you, how does double jeopardy come into play? Is there subrogation involved in employment claims?
I've never seen a subrogation claim in these workers' comp situations. I don't know that the insurance companies are, or the employers are somehow claiming that. And it doesn't seem, especially given the case law, these are two different avenues for relief. They're not mutually exclusive. And I don't think, no one's going to jail. So, double jeopardy is, of course, a criminal law concept.
Yeah, but
by the way, I always emphasize that in my cases, because, nobody, if the employer hasn't been so bad, I'm like, hey, this is not a criminal case, especially the civil rights cases when I'm suing the police. No one's going to jail here. But so I think that on the contrary, employees have rights under workers' compensation. They have rights under FIHA and the other statutes I mentioned, and they can pursue those individually and get compensated in each forum.
That's what I wanted to hit on. Yes.
Yeah, and that's the car case. So I would definitely take a look at that.
Okay, great. And then question came in, isn't there credit against the 132A for any settlement or judgment in a fee Houck case or vice versa?
I mean, they can ask for it. I don't think that there's any. In other words, if it goes to trial, our cases, I don't think that the fact that the person got compensated under 132A would, as I'm reading the law, in any way inhibit us from getting full damages in our cases. Whether the other side of the coin is true, I'm not entirely sure. In other words, if we get compensation for the harassment, would a workers' compensation administrative law judge hold that, well, okay, you can't recover under 132A? As I read this Cower case, I think the answer to that question should be no, but what is done in an individual case can be different, and so I'd be interested to hear if I know there's a lot of folks on the board, but if that's ever happened, where anyone's been precluded from 132A because of something that's happened in an employment case, let us know in the chat or the Q&A. We've got about 10 minutes here.
There you go.
Yeah, I've never had any experience with, anyone trying to, subrogate those claims or, ask for money or anything like that. So just hasn't happened.
There you go. And Jim, a question: how much does workplace violence come into play in what you've seen?
Well, I think it's it's kind of amazing sometimes how many times assaults can happen in the workplace, or at least maybe they end up coming to me when it does. But so there's a case called Fretland. I think that's also I provided that to you to provide in the materials, which basically, if someone is assaulted at work and gets injured, right? Of course, it's a workers' compensation case. But in order to take it out from workers' comp exclusivity, if we can show that the employer engaged in some sort of affirmative misconduct in the way they handled the situation, or in Fretland, they specifically mentioned ratification. Well, ratification could be they didn't fire or discipline the person that went into the assault. In the case that we did so well in federal court in trial, where it was a workplace violence case that we won under 52.1, it wasn't for a protected class in any way. In that instance, our client got fired too. They both got fired for, fighting. And they said, hey, how could we ratify? We fired the guy. But our argument was, and it flew with the trial judge, and we ended up settling before the appeal was decided, was that, but you engaged in affirmative misconduct by firing someone for being a victim of workplace violence, and that's against public policy. So we also had a wrongful termination violation of public policy cause of action that we prevailed in that case. As in this case, the facts were, we had good witnesses that this other guy came and said was choking our client, said, I'm going to kill you. And, he didn't get too far, but because there were other people that got him off. But, still, how could you fire someone? They said our client said he was, the supervisor said our client said, fuck you, excuse my language, everyone, I'm quoting case. But I got into trouble with the judge because my client said, I didn't say that. I said, this guy's fucking crazy. And as I argued the closing argument to this federal court jury, I said, well, the guy's coming at him saying he's going to choke him. He was acting fucking crazy. You can't do that. I found out. You can quote someone else saying the F word, but you shouldn't do it yourself in your closing argument. The judge reamed me out a little after my closing.
That's fun. So, Gian, what are some examples of adverse action besides termination or decrease in wages or choking somebody, calling them fucking crazy? So language as well.
I don't know if that last one is actually an adverse employment action, but it is, it's basically anything that materially or adversely affects, the terms, conditions, or privileges that you have at work. So, the simple ones, like you said, are the, clear-cut ones are like demotion or change in pay or termination. But there could be other things, like maybe your job duties are changed, right? And so things that you were doing and enjoying doing before, and now you have to do crappier duties or whatever it is. Or even we argue that sometimes being put on a performance improvement plan or something like that, write-ups, all of those are adverse employment actions as well, because it kind of puts you on the chopping block, right? And then also, maybe you're moved to a different building, your commute is longer, all of these different things can be potentially adverse employment actions.
Yeah, California law is really expansive on that, and the case law is good. And anything adverse in a performance review that relates to someone's disability or their need to take time off that could result in them not being eligible for promotions and things like that can be considered an adverse employment action. Let's face it, employers mess up on this all the time by penalizing people for being absent from work when they have protected leaves, and they even have it codified into their into their personnel policies.
Mm-hmm.
And so any situation that you have like that, that's where, if the person is getting penalized because of their workplace injury, that's where I think it makes sense to really partner with an employment lawyer.
Yeah, I have a case right now where it's a written policy that you need to give at least, 48 hours notice before PTO, or otherwise it's called an unplanned PTO. And if you accumulate too many unplanned PTOs, then you're fired, right? Of course, if you have a flare up of an injury or something that prevents you from working, you can't give 48 hours notice. So this person was on its face terminated because of their disability, because they had to call out because they were not physically able to come in that day.
Makes sense. Yeah. I do have a COVID question here. So derivative action relates to COVID. Numerous people contracted COVID at the workplace. Applicant left for vacation with the family, ended up on a ventilator, as did his mom, and the mom died. So am I duty bound to add death claim for the mom?
Well, duty bound, and I'm not sure if that question is, am I duty bound in the workers' compensation claim to add death claim? I don't know if you can or not, but certainly based on that See's Candy case, you can have a wrongful death action for, I believe that you could have a wrongful death action for mom because she contracted it from, assuming, this is all subject to proof, right? I mean, they're going on vacation during COVID. So where are they going? Did they fly in a plane? It's still subject to any sort of evidentiary burdens of proving that more likely than not. But remember, it's the more likely than not standard. Nothing's ever 100% in medicine, right? But I think, yes. And I think the prudent thing to do would be to, make sure that you're referring them to if you're not handling the civil case, or maybe working with a civil lawyer to advance those claims. But I think absolutely you have a case there. I think if you know about a case when they come to you, you're duty bound to explore that with them.
Good deal. So last question I have for you. What should a workers' comp applicant attorney look for in an employment attorney before referring these cases out?
Well, I made a joke beforehand. I said, look for my number. No.
What are some of the things they should look out for? How about that for a question? What are some of the things they should look out for when referring something out? Is there anything that they should look out for?
I think it's the same for when you refer out any cases, right? I mean, you want to, make sure that the person is competent in handling it. These are cases that they regularly handle, and they know what they're doing. Certainly, maybe talking to other folks who refer cases to that person can help and learn their track record. I don't know. That's generally what I think about when I think of, referring out cases.
And I think you really want to look for someone that you can get along with. It's like, to me, I love collaborating with most attorneys, but not all attorneys. There's some that you say, all right, well, that was good, but I may not work with that person again. So you really want someone who will collaborate with you, who's not going to be trying to be a control freak. They understand there's two cases simultaneously, and you've got to work together for the best interest of the client. Someone who's client-centered, not money-centered. We all need to, keep the train rolling and make a good living in the work that we do. Ultimately, I try to look at what is in the best interest of this particular client, and that may not be what's in my best interest as far as the bottom line. It's what's good for them. And you want someone with experience, and I think you also want to. I think someone who has some trial experience. If you can get someone. I think that ultimately, while most cases settle, it's the attorneys who are holding the hammer of trial over the defendant's head that can get the best settlements for clients, and those that are willing to go to the mat and take cases to trial that can be the best lawyers to work with in these cases.
Good deal. All right. And on that note, one of the things that I am going to do is include both Jim and Gian's contact information on a follow-up email, along with a copy of the recording, which again, you'll also be able to find on our YouTube channel. I do want to thank both Jim and Gian for joining us and participating on this panel. I think it was some great information. With that, I'm going to go ahead and close this out, and have a great day.
All right. Thanks for having us. It was a lot of fun.
Thanks,
Yes,
guys.
thank you very much, John. Take
All
good
right.
care.
Thank you. Take care.
Alrighty.